I heard that Ryan Reynolds wrote a scene for the film. Is that true?
Look, I think that I'm pretty sure that everybody at some point wrote something for the film. And yeah, Ryan, Blake, and I was just so grateful that there's so many collective heads going in to try to make something so beautiful.
Do you remember
And
which scene?
he wrote on a few scenes, I believe, and suggested a lot of things that made the movie better. I mean, the guy's a creative genius, and they work so well together.
Well, she told me Taylor Swift helped her get the role, like signed off on her
Well,
audition
I
tape.
had brought in, I was casting, and I had actually brought in and showed her casting tape to Blake and Taylor, and they were both like, "Yes, her." And that's a true story.
Hi, besties. It's Katie from Without a Crystal Ball. Okay, it's Tuesday. We had a lot we had to cover yesterday. There's crime fraud exceptions, there's allegations of criminal misconduct, there's allegations of crimes that have occurred, there's allegations of civil torts, there's all these things happening right now. And then there's fights over discovery as it relates to Baldoni versus Lively and Jones and Reynolds and this whole big dispute that we've been covering for months. And we got a response from Wayfair regarding the motions to compel financial records. And then Kristen Taylor responded with her 3-page letter to the judge about why they should not allow Wayfair to get access to the security company that extracted data from Jen Abel's phone. Okay. And we learned that despite the fact that they have stated publicly numerous times that they got all of these records and the evidence in this case from a court ordered lawful subpoena in a lawsuit that was lawful. That's the key here. Wayfair disputes those claims. Blake Lively has not yet cooperated with discovery and provided Wayfair with a copy of the subpoena so that the subpoena can be reviewed by Wayfair to see what documents she sought from Stephanie Jones. And document discovery, we've learned, has not even begun because they just finally entered into a stipulated agreement about electronic storage for all of the discovery that comes in. That's both electronic and hard copy paper discovery, how it'll be stored, how they're going to classify it, what codes they're going to use, how they can search for documents, which is a joint stipulation they all filed and all agreed on as an order for how they will disclose paperwork to each other. So they finally entered into a stipulated ESI agreement, which is quite boring, but it's how they organize the discovery and preserve the evidence for the case. And so now that that's been agreed upon, maybe now they'll start actually producing documents to one another. But at this point, no subpoena has been provided to Wayfair, despite repeated public statements by both Lively's attorneys and by Jonesworks attorneys that this was a lawful subpoena from a lawful court-ordered lawsuit, which we now know is called Van Sham. Now, before we kind of dive into what we know about the subpoena, someone either connected to Stephanie Jones or to Blake Lively leaked it to the press. They leaked it to Daily Mail and Deadline. And under the strict rules that they couldn't disclose information about where the subpoena came from and what it was seeking. Deadline revealed in an article a couple weeks ago that it named Lively and Reynolds and the couple's various companies and entities, and the subpoena concerns and refers, relates, and applies to any and all electronic records, data, documents, and communications in your possessions, custody, or control collected from a cellular telephone containing the requested information from December 1st, 2022 onward. And the material was handed over not long afterwards. It's interesting that the subpoena was seeking information on the cellular telephone, but then they don't state whose cellular telephone it was. Again, not intentionally excluding Jen's name because then Jen would maybe have to be notified. But her attorneys filed a letter yesterday about they needed to get a leave and they needed to do more pages than necessary and they needed to argue about this crime fraud exception. So there's been a lot of issues lately with Wayfair and third-party subpoenas, trying to get information from third parties that are not necessarily parties to the lawsuit, but that have information. And there's been a number of motions to quash or protective orders, and this one is about Edgeworth security. And Kristen is answering the crime fraud exception, and she claims that she was ambushed by this, and they assert an outlandish theory that they never raised before. In fairness, they didn't know about the subpoena until like a month ago, so they couldn't have possibly raised it until recently. But again, they her argument is that they're seeking this exception, but they haven't provided any evidence whatsoever about the actual crime that occurred, and that they have a burden to submit evidence establishing probable cause that the crime fraud exception applies. Then she provides a few different arguments as to why they've failed to properly argue this. So they say they fail to even attempt to connect any of their arguments to any particular privileged document or documents. They don't even try to explain, for example, how the category of documents from May 2024 that relate to defamation against Jones works 3 months before Abel's termination could have been intended to facilitate an undefined purported scheme related to post-termination conduct and events. The crime fraud exception, they say, only applies where there is probable cause to believe that the particular communication was intended in some way to facilitate or to conceal criminal activity. And then the other thing is that they say that Wayfair parties present no evidence of their outrageous allegations against Jones Works. They present no evidence of their allegations that Jennifer Abel was falsely imprisoned by Edgeworth security personnel, that present no evidence of their false allegations that Abel was coerced by Jones Works to return the phone Jones Works provided to her for her employment. They present no evidence that Jones Works accessed everything from her personal iCloud and email accounts. And they present no evidence of any of the specious criminal hacking allegations they level against Jones Works. Instead, the only documents they cite for the allegations is Abel's own amended counter complaint, which is equally unsubstantiated, unverified, and unsupported. But a complaint is not evidence. I mean, I guess she's got to argue for Jones, but the same could be said for Jones's allegations against Abel. You know what I mean? Like, these are civil allegations at this point, and I don't know. There's parts of these arguments about discovery and what has to be turned over that just bothers me because at this point, nothing is a fact, right? Nothing is a fact on both sides. Honestly, it goes both ways. They said the counter complaint that's unsubstantiated, unverified, and unsupported. And the allegations in the complaint cannot suffice to establish probable cause to believe that a fraud was perpetuated. Otherwise, through the mere allegations of fraud in a complaint, a party could use the crime fraud exception to wholly swallow the attorney-client privilege. Indeed, Jones Works has moved to dismiss Abel's amended counterclaims because the allegations are not only false, but they would fail to support any legal theory she advances. And Wayfair presents no evidence of a crime, a fraud, or Jones Works' involvement in either. So they're really relying heavily on this concept that the crime that Wayfair is asserting happened was that she had to hand over a phone, okay, without her consent, and that she was falsely imprisoned. I didn't necessarily read that as what the crime was or the fraud that occurred. I felt like the fraud they were trying to demonstrate was that they had done the subpoena through the sham lawsuit. That's kind of what I took. And she addresses this briefly. In fact, the Wayfair parties present only two documents other than their own prior pleadings in purported support of their argument: a complaint filed by a third party, not Edgeworth, in New York Supreme Court, and a notice of discontinuance of that litigation. Well, she's at least acknowledging that this happened, right? Neither of these documents offer any factual or evidentiary support for any of the Wayfair parties' wild claims. They do not relate to Abel's termination in August. They do not relate to Abel's return of her Jones Works owned iPhone, to the company at the time of that termination or alleged access thereafter. Even the Wayfair party's effort to connect these two documents to Jones Works is supported by nothing more than wild speculation and yet more bald repetitions of things the Wayfair parties previously alleged. I mean, she just indirectly admitted that that sham lawsuit had nothing to do with Jen Abel, which begs the question, why did Jones turn over Jen Abel's phone contents if that lawsuit had nothing to do with Jen Abel's phone or her termination? None of this approaches the showing necessary to support invocation of crime fraud exception. Their effort to connect these two documents to Jones Works is supported by nothing more than wild speculation. Deadline put out an article, and so did the Daily Mail, because they saw this reported subpoena. And it was only given to them by someone that had the subpoena, right? And both sides went on record and reported that the Van Zandt lawsuit was where the subpoena was issued from. So it just seems odd that they're trying to now say it's a wild speculation that Jones Works is tied to this action. Well, I mean, it is, because why would they be tied to an action that has nothing to do with them? What's more, despite their bombastic allegations of a sham action, I don't think it's bombastic, Kristen, those allegations, even taken on their face, fall short of establishing any cognate theory of a crime or fraud involving Jones Works and Edgeworth that would support the exception. The case that Wayfair parties cite confirm this. Their rhetoric aside, their bald allegation that Jones Works colluded with Lively to issue a lawful subpoena in a case that Lively purportedly did not intend to fully litigate falls well short of fraud corrupting the administration of justice that could sustain the exception. So they're admitting maybe that Jones Works colluded to issue a lawful subpoena. That's not really what they said. It's like she's dancing around the fact that there was no defendants. There was nobody listed as a defendant, no parties listed, no one was listed. Their lack of evidence is unsurprising as the facts they assert are false. Oh, so I guess they didn't get that data through the sham lawsuit or sham subpoena. Oh, now she's going back to the crimes that happened with the phone. So Jones Works did not imprison Abel. It terminated her employment in a conference room. It did not coerce her. It provided her documents that she reviewed and signed. It did not threaten her. It requested that she return the iPhone that belonged to it, and she did. It did not hack her iCloud account or email accounts or even access those accounts or any personal information. It forensically extracted data from the storage of an iPhone it provided to its employee to use during her employment. If the Wayfair parties had evidence supporting any of their inflammatory assertions, they would have presented it to this court. That they did not both confirms the non-existence of evidence and defeats their opposition. So she's not saying that they didn't use this lawsuit, the sham lawsuit, to have Stephanie issue all of this and turn this all over to Lively. They're just sort of like trying to redirect and say that there was no evidence. They're just making wild allegations. It's mere speculation. And then really trying to downplay the use of a sham lawsuit where no one's named and it's asking for a cell phone. Now, in fairness, the cell phone and subpoena stuff was given to the press, by the way, not given to the court. It seems odd, if I'm going to be completely honest, that we're this far into discovery. And despite repeated attempts to get a copy of that subpoena, they haven't turned it over. And crime fraud exception aside, I feel like a lot of these filings by Wayfair are really at the heart of this, trying to get that subpoena. They want to see what's on that subpoena, and nobody's giving up the subpoena, which begs the question, why are you hiding the subpoena? You are literally saying that it's a bombastic allegation of a sham action, but you're admitting and have admitted on to Billy Bush that these kinds of lawsuits are standard and normal and can be used.
Question is, did she know that the subpoena was coming from a Blake Lively shell company?
The Doe lawsuit is a common lawsuit.
Is it an end around while it's legal?
It's absolutely not an end around. It's a common practice that if somebody's defamed, somebody's smeared, if something happens and they don't know who did it, then they can file a lawsuit. BillyBushIsTerrible.com. You don't know who did it. You want to find the person who has that website out there. You can file a Doe lawsuit where there's a plaintiff against Does to find that out.
And they said that the timing of the opposition coming just 2 hours after the motion, its assertion of an argument not mentioned in over a month of conferrals and reference to a since abandoned claim all demonstrate their response was pre-baked, media-targeted ambush, not a reasonable response to resolving a legal dispute. The tactic should not be indulged, and because the opposition fails even the most basic requirements of invoking the crime fraud exception, the court should reject it and grant Jones Works' motion for the protective order. I know that Kristen wasn't involved in this sham lawsuit, and now they have to defend it. And Blake and Stephanie got terrible legal advice, and Manat is the one that facilitated this. But for these attorneys to keep perpetuating and gaslighting and acting like this lawsuit was real, and here she's trying to deny that Jones Works is connected. But Ezra Hudson and Michael Gottlieb spoke to Deadline and said, there's nothing untoward here, just conscientious and thorough investigation. The lively parties acted upon reliable information and employed common tools such as a Doe lawsuit and civil subpoena that are entirely lawful and appropriate for pursuing claims and uncovering the identity of unknown perpetrators of unlawful activities. This lawsuit unearthed the Wayfair parties' documented plan in their own words, in their own text messages, to destroy Blake Lively as a plan which they executed without transparency, disclosure, or notice to Miss Lively or the public, instead acting in a way they thought would be untraceable. We have absolutely nothing to hide. Miss Lively voluntarily disclosed the subpoena in her first filing, knowing that it would be ultimately produced to the Wayfair parties in discovery, and that is precisely what will happen as her claims move forward in the proper litigation process. So her attorney said this is where the doc information came from, where Jones is telling the court, well, you can't link us to that. I know that the judge isn't looking at articles and isn't looking at interviews and public statements, but the fact that they're telling this to the press and then they're saying something quite entirely different to the judge, I don't like that. And they're accusing Wayfair of doing all of these end arounds to try to get information, but that's precisely what they did with the sham lawsuit. Even with these third-party subpoenas that Wayfair has issued, they're issuing it as a part of this litigation. And if the parties intervene and want to quash the subpoena, they can do that. So it's different than saying what Wayfair is doing here is an end around, because they're obviously giving this party an option to quash. And it's up to the judge to decide if they'll quash it or if they'll put a protective order in, right? They have a right, Wayfair does, to subpoena third parties. That's what the point of a third party subpoena is. Parties don't get subpoenaed, by the way, you guys. And so they're subpoenaing Edgeworth for their communications with Jones, which technically speaking, Edgeworth and Jones speaking is not privileged at all. If they had conversations just with Jones or Jones Works, those are not privileged. And they weren't seeking privileged information. It was her attorneys that said it was all privileged. And they want Edgeworth to comply. I don't know what the judge is going to do in this case. But when it comes to other third parties, last week we know that Taylor Swift's was subpoenaed, okay? And yesterday, Taylor Swift's attorney, Douglas Baldridge, who's based out of Washington, D.C., and works for Venable, filed a motion to quash in the District of Columbia's federal court to quash a third-party subpoena where Wayfair is seeking conversations between Taylor Swift's attorneys and Ryan and Blake's attorneys, and Taylor Swift's attorneys with Ryan and Blake, not clients but they're conversations, which are actually not privileged. I just learned that through Not Actually Golden on TikTok. So anybody that isn't represented by an attorney that speaks to them, their conversations are not privileged. So if the attorney, Michael Gottlieb, that represents Blake and Ryan, is coordinating with Taylor Swift's attorney, it appears that Wayfair wants to know what it is that they're coordinating about. What is it that they're talking about? What are they trying to organize here? And it could very likely be to see if Taylor got incentives here. How involved was Taylor with not only this litigation, but also are they cooperating on this case? Did they cooperate when it came to the film? What kind of conversations are they having about this lawsuit? And according to what they provided to the court, they provide what the subpoena includes. And it was issued on April 29th. And it says all communications between you and including without limitation Baldridge and the Lively parties, including without limitation their counsel concerning the action. So they're looking for information regarding this action, this lawsuit. All documents concerning communications between you, including without limitation Baldridge, and the Lively parties, including without limitation their counsel concerning the action. All communications between Baldridge and Gottlieb concerning Blake Lively from June 1st, 2024 to the present. Baldridge should include Douglas Baldridge. Gottlieb should mean Michael Gottlieb. Action shall mean the lawsuits. And Lively party shall mean Blake and Ryan, as well as their employees, representatives, agents, subsidiaries, affiliates, blah, blah, blah. So they're seeking information from them about this litigation and the claims in this litigation, about what was Blake saying to Taylor's attorneys? What was Michael Gottlieb saying to Taylor's attorneys? Are they working together on this? Now, interestingly, Taylor's attorneys did state in this motion to quash that they take no position whatsoever on the case at hand. So there's a footnote in their motion to quash, and they talk about this underlying lawsuit. And they said all the facts about the underlying lawsuits are taken from public filings on the lawsuit's dockets or other publicly available resources. None has been confirmed as true by Venable, and Venable takes no position on the public allegations. Venable cites the allegations only to show that the discovery sought from Venable is irrelevant and unwarranted. So they're not saying that any of the allegations on either side are true. They're saying that they take no position, meaning they're trying to say we're not pro-Lively here. Maybe trying to distance Taylor from it too, because Douglas Bainbridge, if he's talking to Lively and Reynolds or Gottlieb, is only talking to them about Taylor Swift. That's it. And Taylor's name is not mentioned at all in here. And so it's different than the subpoena that she got because they do reference that they were contacted by them last week if they would accept service for one of their clients. On May 8th, 2025, attorneys for Wayfair sent Douglas Baldridge a different third-party subpoena directed at one of their clients and asked Ms. Baldridge if he was authorized to accept service on the behalf of that client. To date, Wayfair has not asserted that Venable has relevant information underlying claims and defenses due to its representation of a client, nor would such an assertion be proper. So they're trying to distance themselves and say Venable has nothing to do with the film. They have nothing to do with these claims. They are not involved just because they represent Taylor Swift. And it's very similar to the position that Taylor took publicly when her people said that Taylor had no involvement, which begs the question, was Taylor really involved in the casting, as Blake Lively has said and as Justin Baldoni said, or was that just a lie that Blake made and then Justin had to go with it publicly because of what Blake said? I don't know. Was her music licensed in the film? Yes. Are there questions around why a certain composer was hired and another one was fired? And was it related to Taylor Swift wanting a composer fired? Yes, but she says she had nothing to do with the music, nothing to do with the editing, nothing to do with casting, nothing to do with hiring. So did Blake then lie to Wayfair and say that I had to fire your composer because Taylor won't work with them? So was she trying to deflect onto, well, Taylor won't do it, so it was a way for her to get her own composer on? I think part of the reason they're subpoenaing Taylor is to figure out what Blake actually said to Taylor and what Taylor's actual involvement is. Because Blake made it appear like Taylor was so involved. But if she's lying about Taylor's involvement and she was doing this all behind Taylor's back and representing to Wayfair that it was Taylor that wanted people fired, it was Taylor that had to have this other music in, it was Taylor that needed this editor to come on, it was Taylor, Taylor, Taylor. If she used Taylor as leverage to get her own cut and Taylor had nothing to do with that, then that can poke holes in her credibility. So if she's willing to lie about Taylor and Taylor's involvement, what else is she willing to lie about? And listen, I don't know what Taylor's involvement is, but if Taylor has nothing to hide, the best thing that she can do is respond to the subpoena, provide what she has that's relevant, and move on. And if there's a deposition sought, answer the questions as truthfully as possible and move on. But if you don't want to comply and you think there's nothing relevant, the reason she's being brought into this is not because of Justin, it's because of Blake. Now, I don't know if a motion to quash is going to come from Taylor yet. That hasn't happened. She just got her subpoena. And I'm sure she's talking with lawyers at the present to figure out what she's going to do. But regardless, Wayfair's using their third party subpoenas strategically to investigate the scope of what these third parties did and know that enabled the extortion and the defamation and the takeover of the film by Lively and Reynolds. And they have a right to issue these subpoenas. The judges have a right to quash. Wayfair hasn't responded to the motion and the DC case. They're going to have to get a DC attorney now. And then they didn't respond to Kristen because they can only respond to Kristen unless they file a leave to file, because the judge already said no more responses unless there's a leave to file to the court. So right now, they haven't responded to that subpoena, and they have yet to respond to what's happening in DC. So we'll have to see how this all plays out. It would appear that everyone's accusing them of doing this for a fishing expedition, but it would appear they're trying to figure out what Blake and Ryan were doing behind the scenes with, and what Stephanie was doing behind the scenes with the company that extracted the data, which they're claiming they didn't get into the iCloud, they didn't get into the emails. There has to be evidence from Jen Abel that she knows that they got something from either a Gmail account or from her iCloud that she knows would have been taken only from the iCloud. And Kristen says nothing was taken from there. But Kristen wasn't involved in that subpoena, so how would she know? She wasn't involved in the extraction either. So how would she know? Is she going off the word of Stephanie? Because that word is, we already know about that. And Baldoni's attorneys basically asked the court about financial damages and financial records, and they sent that late last night to the judge. So Kevin Fritz told the judge that contradictory statements. Lively simultaneously acknowledges that the Wayfair parties have confirmed that they will produce non-privileged documents concerning their damages, and incorrectly argues that the Wayfair parties have refused to produce specific financial records relevant to their damages. Given that there is no need for judicial intervention at this juncture, it appears that Lively's true purpose in filing the motion was not to compel discovery, but to fabricate a headline for the media, regardless of whether the motion wastes judicial resources or not. And for good measure, it is worth noting that Lively herself has not produced a single document or explained how she searched for and collected the documents that her counsel claims to have gathered from her, but not produced to us. So basically, like, why are you coming to the judge when you haven't given us anything either, Blake? During the parties' meet and confer, Wayfair parties assured Lively they were in the process of gathering documents responsive to her requests and that they would produce non-privileged documents concerning their respective damages. Contrary to her ongoing mischaracterizations to the court, they did not refuse to produce the requested documents bearing on that loss. Furthermore, the Wayfair parties suggested that if upon receiving the damage-related documents the Wayfair parties produced, Lively believed that additional documents should be produced, then she should notify them of that position, and they could meet and confer in good faith about that topic. They argue the Wayfair parties have already agreed to produce documents concerning their damages, which documents may include, for instance, financial statements reflecting a reduction of business revenue. However, the motion fails to explain why the net worth of each of the Wayfair parties is relevant to any party's claim or defense and proportional to the needs of this case, and denying the application for disclosure of defendants' assets because plaintiffs made no showing that defendants' current financial condition or net worth bears a relation to the application for relief. They also are they argue about the private nature of tax returns. And so instead of handing over tax records, you look for producing less invasive documents because tax documents include a lot of sensitive information. They argue whenever Lively identifies the relevant information from the tax returns that she purportedly needs, we are confident that any such information will be readily available from a less intrusive source. None of the cases that she's cited to the judge warrant handing over documents of tax returns, but then they point this out. Lively also refers in passing to her RFP seeking all documents concerning your liquidation of assets in 2024 or 2025 for any reason related to the film or the actions, including but not limited to the sale of shares in any publicly traded company. Nowhere in her 3-page letter does Lively even attempt to explain, let alone sufficiently explain, how any such responsive documents are relevant to any party's claim or defense. During the meet and confer, Lively did not provide any basis for seeking documents concerning the liquidation of assets by any of the Wayfair parties. Indeed, even in her self-serving and lengthy summary and memorialization of the meet and confer, she does not explain why documents concerning any liquidation of assets is relevant. And then they want the judge, to deny this because she failed to meet and confer about her requests for documents concerning liquidation of assets in violation of Rule 4C of his individual practices. So we'll see what the judge rules on that. So there's a lot going on. You got Taylor Swift's attorneys getting involved. You've got Kristen. You've got Wayfair now responding about the financial documents, and they have a set stipulation for how they're going to warehouse the documents. So documents are going to start getting produced soon. But right now they're fighting over what needs to be compelled and what doesn't, and what needs to be quashed and what doesn't. What are your thoughts? Do you think Kristen's covering? Do you think she's lying? What do you think about Taylor's attorneys taking no position, basically saying Taylor takes no position, which is kind of shocking? And what do you think about Blake and Ryan? Tell me in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed, and click the bell so you never miss a video. Thanks so much for watching. Bye, guys.